let's dive into the material that I think is important for you to understand as it relates to the law of personal property, wealth transfer, and intellectual property. By way of mini review, we have thus far talked about property law as being the law of value. We have recognized that the law of value, the law of property, is divided into these two separate, distinct, but very important concepts of property law, the law of real property and the law of personal property. In fact, you really could, if you wish, consider these two areas of law, real property and personal property, to be different areas of substantive law altogether. Because while they certainly address the law of value and the same legal issues, such as transfer and loss, and tax and insurance, and what happens when someone dies and liability. I mean, those are all kind of the legal questions that we apply the law of property to, and we get somewhat different answers depending upon if the property interest is real property as opposed to personal property. These concepts are answered differently depending upon the very first categorization, and that is the value that we're talking about a real property interest or a personal property interest? And in fact, if there is anything that years from now I want you to remember about our discussions and our overview of property, is I want for the remainder of your lifetime, you always to have the ability to correctly look at things of value and know from the outset, is this real property or is this personal property? Because that division alone, understanding that distinction will pay dividends to you as it relates to understanding the ramifications of all of the other legal questions that come thereafter. Again, someone dies, how do we divide up their property? There is a transfer of property through the buying and selling of a business. How do we distinguish how the transfer of assets takes place? There is loss that is sustained by a business, your restaurant, your hotel, your business sustains fire damage, earthquake damage, flood damage. How are property or how is property replaced? How do we value that property? A business is subject to a bankruptcy proceeding. What happens? How do we protect property? Maybe there's a judgment that enters against you or your business, or you have a judgment in your favor and you're trying to collect on that judgment. How do we go about collecting assets? These are concepts that we'll continue to talk about as we look at business liability in part 4 of the course. But for our purposes, this distinction between real and personal property is something I've spent a lot of time on, and it's not complicated, but it is always your starting point and something to remember, and a key takeaway for purposes of the class. As we looked at the law of real property, we talked about the estates in land, the estates in real property that exist, the fact that those estates in land are created by document. We've talked about the fact that any interest that one has in land is an estate in that land, but that doesn't necessarily mean that a right of possession exists. Possession, as we discussed, is the ability to use an asset and exclude others from the use of that asset. And certainly when we have an easement, we have a real property estate in land, but it's not exclusive. We can't exclude others from the use of that asset. So these are concepts that we talked about when we looked at the law of real property, joint ownership of property, the transfer of property, both voluntarily and involuntarily, the limitations that are placed upon the use of property in the form of zoning restrictions, or the conditions that are placed upon the use of property when a conditional estate is created. All concepts that I'll review with you one more time when we get to the review lecture. But we move past our discussion of the law of real property, at least for now, and we look at, in contrast, the law of tangible property and the law, as we refer to it, as of intellectual property, copyrights, patents, trademarks, trade secrets, and those are all within the big tent, if you will, the concept, the subcategory of property that is known as personal property. And so if I can go to the lecture slides. We'll get to the law of personal property. Personal property is, as I have defined for you previously, kind of the catch-all of anything that is of value that is not deemed or determined to be real in nature. Again, real property, as we defined, is the land and anything that is permanently attached to the land. And then by default, anything that is not covered by the law of real property is considered to be personal property. So anything of value that is not the land or that which is permanently attached to the land, such as a building or a home or a condominium, is by definition considered to be personal property in nature. And the law of personal property is then divided into, if you will, two categories. Tangible personal property, that which is in a physical form, that which can be picked up and moved from place to place, and intangible property, that property that has a value associated with it, not based upon something that can be physical in nature, but nevertheless something that we equate with value based upon our mind. I gave you previously the example of, paper, one of which is green and white and has Abraham Lincoln on the face of the paper and has a 5 on it, and the same weight, the same paper, the same color, but a picture of George Washington and a 1 on that paper. And in our mind, we recognize that there is 5 times the value in a $5 bill as opposed to a $1 bill, even though physically the paper has no distinguishable difference to it. It's the same weight, it's the same color, it costs the same to produce, and yet in our mind, we naturally recognize that one of those pieces of paper has 5 times the value of the other. This intangible value that we associate with property is covered by the law of intangible personal property. And so there is a logical sequencing that you have to apply to property. And the only time, if you think about it, that we really concern ourselves with, the progression of thought is to get to the answer of a legal question that will arise that necessitates our knowing the distinction, the difference between if the property in issue is a real property interest or a personal property interest. And so when would we need to know the distinction? When would our recognition of the difference between personal property and real property, and our recognition of the distinction between tangible property and intangible property, when would that get put to the test? When would you need to know these types of things? Well, in no particular order, when there is loss and perhaps an insurable interest, when there is a judgment and the necessity of looking at collection on that judgment, when we are seeking to borrow money and we wish to pledge as security assets, wealth, property, when there is death and we're trying to determine who receives property and what it is that they receive upon the death of the owner of that property. And certainly, as we started really this whole segment of the course discussing, what about tax? To what extent is the government entitled to tax assets? And to what extent even are we able to depreciate the value of those assets over the time period within which we own those assets? And the depreciation of personal property and the ability to depreciate personal property, the law is different than with respect to our ability to depreciate or even any ability to depreciate real property. So you see, and I think a picture is oftentimes worth 1,000 words. You see, the little vehicle on this lecture side denoting tangible personal property. You see the stock certificate certainly denoting the concept of intangible personal property. Now, one of the areas in which this distinction between tangible personal property, intangible personal property, and certainly real property becomes significant is when someone dies. And so what I wish to do for a few moments is go through with you the issues of wealth transfer at the time someone dies. And in so doing, I wish to bring to your attention that all wealth that exists, all assets that people have, passes at the time of death to others. We cannot take with us upon our death whatever might happen to us upon our death. We have with us the necessity and the ability to separate out the assets from someone who controls those assets during their lifetime and what happens to those assets at the time of their death. And while this is something that is not something that you have to worry about in your own lives, fortunately, anytime soon, this is certainly something that you should have a working knowledge of, because you will have family members who will pass away, and you will ultimately have your own families, many of you, that you will be planning for in the years to come. And so let me go through with you the concepts of wealth transfer and try to give you an understanding of how these concepts work in the world of 2021, 2022. When a person dies, what we do is we actually look at all of the assets that they held an interest in at the time of their death. And we categorize those assets, and we begin with looking at, are those assets real property in nature, or are they personal property in nature? And the three methods of wealth transfer that apply are, first and foremost, is there the possibility that there will be a survivorship right that will pass automatically by property law principles to some joint owner of that property? That's the first thing that we look at. How was the property titled? And is there the possibility that the asset that we're looking at passes automatically by property law principles to a surviving co-owner? The second thing that we'll look at is it the type of asset that we can designate a beneficiary of so that when a person dies, or when the person who has died has during their lifetime been able to, and have they exercised their ability to designate a beneficiary of an asset. And these are wealth transfer concepts wherein we actually apply contract law principles. And then the third method of wealth transfer that we utilize in default of wealth that passes to a surviving co-owner or to a designated beneficiary is what we refer to as probate. And that's where we'll actually look to a person's will. And if they don't have a will, we'll look to the prevailing law in the jurisdiction within which they died, which is known as the intestacy statute. So what happens to a person upon their death is we will apply these three methods of wealth transfer. And likely the more property that they have, the greater the likelihood that maybe all three methods of wealth transfer will be applicable. How does joint ownership of property work? Well, as we talked about when we looked at real property law, we can hold title to real property in our own name. But we can also hold title to real property jointly with others. And when we hold real property jointly with others, we look to the legal relationship between the joint owners of that property. If you have joint property, real property, titled between spouses, and the spouses were married to each other at the time they took title to that real property, there will be a presumption of survivorship. So if you have a married couple and at the time they take title to real property jointly, they are married to each other, they will be viewed as an indistinguishable entity, that married couple. And when one of them dies, there is automatic transfer of that property to the survivor. There is no other way around survivorship of jointly titled real property as between spouses, unless you're able to actually establish that one spouse has intentionally brought about the death of another. That's how indestructible the survivorship presumption of real property is as between a married couple, so long as they took title to that real property jointly while married to each other. In fact, I own my home jointly with my wife. We took title together whilst married. If I leave in my will that my home is to pass to Michigan State University and I die, the provisions of my will leaving the home to Michigan State University are inconsequential. They mean nothing. Why? Because by operation of property law principles, the home passes to my wife. End of story. If the joint owners of real property are not married to each other at the time they take title jointly to that real property, the presumption is that there will not be survivorship between the two. When the first joint owner dies, his or her interest will pass to his or her estate. That's where we will look to their will to see whom the asset passes to, whom their interest in the property passes to. That's a probate asset. Now, is it possible for joint owners of real property who didn't take title jointly while married to each other, is it possible for them to leave their interest in property to one another? Yes. This is what is called a joint tenancy with right of survivorship, but they must specify in the deed, in the document under which they took title, they must specify that they wish for there to be survivorship rights. If I choose to leave my cottage, I don't own one, but if I choose to leave my cottage someday, if I ever own one, to my children jointly with right of survivorship, then they would take title to my cottage as a joint ownership group. And when one of them dies, the survivors of them, the surviving children, would be the owners. This is not presumed. If the document itself doesn't specify that there will be survivorship rights, then by default, the real estate will pass to the estate of the person who held the interest in that real property. So in sum, with real property, we look to, was the person who died married at the time he or she took title to the property? Did they take title jointly with their spouse? In those circumstances, there will be a presumption of survivorship that is actually irrebuttable as between spouses. If the real property that is held jointly is not with one's spouse, there will be a presumption that the interest passes to his or her estate upon death, unless the document specifies, that there will be survivorship with the surviving owner. None of this applies if the property interest is personal property. This is where that distinction between real property and personal property is so significant. If you own personal property joint with another and die, the interest that you hold in that personal property is presumed to pass to the surviving co-owner. So if there is a bank account that is joint between you and I die, the proceeds of that bank account are yours. If there is a car that is titled jointly between you and I die, that car is yours. If there is stock that is titled jointly between you and I die, that stock is yours. It doesn't matter the fact that we're not married or even not related to one another. With personal property, there is a presumption of survivorship as between the first owner of that personal property and whoever it is that survives them. The second method of wealth transfer, and something that I suspect should make absolute sense to you, is there is certain wealth that one does hold in their own name that they don't hold joint with others. And if allowed, part of the controlling documents for that wealth will permit the owner of that wealth to designate whom the beneficiary of those assets, that wealth, should be at the time of their death. There is, in fact, a great amount of wealth that exists in 2021 that we are allowed to pass upon our death by operation of contract law principles. 401k, 403b, IRAs, life insurance policies, bank accounts. You open up a bank account at the MSU Federal Credit Union. First question that you'll get asked, who's the title holder? Who owns the account? It's you. Second question that you'll get asked, to whom should that account pass at the time or in the event of your death? Who's the beneficiary of that asset? This is the utilization of contract law principles. We specify in the controlling document, in the contract, whom we'd like the assets to pass to in the event of our death. And the law recognizes those beneficiary designations, and the beneficiary designations are actually controlling with respect to wealth transfers. There was a famous case back in 2001 that the United States Supreme Court took up. The case was called Egelhoff versus Egelhoff. In the Egelhoff case, these are basically the facts of the case. Mr. and Mrs. Egelhoff divorced. Both of them had been previously married. Both of them had children from their prior marriage. And under the terms of the divorce decree, Mr. Egelhoff was awarded his 401k, and Mrs. Egelhoff basically got the rest of the assets of the marriage. About 3 months after the divorce was finalized, Mr. Egelhoff dies in a automobile accident. And the proceeds of the 401k are at issue because the beneficiary that he has listed on his 401k is the ex-Mrs. Egelhoff. The case goes all the way to the United States Supreme Court, wherein the United States Supreme Court opines that the beneficiary who is entitled to the 401k proceeds is the ex-Mrs. Egelhoff, probably the last person on the planet that Egelhoff really wanted to get those 401k monies. The issue was, under the law of most states, when there is divorce, the law applies that any assets that were jointly owned or would have passed to the spouse under a will or decedent's probate estate are invalidated. Those disposition terms are canceled. It's as if you have predeceased your now divorced spouse. So if these were assets that would have passed through joint ownership to Mrs. Egelhoff, the ex-Mrs. Egelhoff, or to the ex-Mrs. Egelhoff through Egelhoff's will, she wouldn't have gotten anything. But these were assets that were passing to the ex-Mrs. Egelhoff pursuant to the terms of a contract. And the Supreme Court opined that contract law principles, if they can be followed, are to be followed. What Mr. Egelhoff needed to do was, when the 401k was awarded to him, it was his, he needed to go and change the beneficiary designation on that 401k contract. He didn't do that. The 401k contract clearly specified that the 401k was to be paid to the beneficiary on file with the 401k fiduciary at the time of Egelhoff's death, and the listed beneficiary was his ex-wife. She prevails, she gets the money. The point of the illustration isn't that you need to know that case. The point of the illustration is that as you move forward, you need to keep track always of, one, how your assets are titled, and two, as you have the opportunity to designate beneficiaries on wealth, such as bank accounts, retirement accounts, pension, 401k, IRA, SEP, and oftentimes you're going to get employment, and there's going to be nothing in those accounts when you start working for your employer. And on day one, you're going to be sitting there thinking, wait a second, I got all this debt and I've had very few assets, but those designated beneficiary provisions matter. The final method of wealth transfer, as we talked about, is probate. Probate is a default method of wealth transfer. It only applies to wealth that doesn't pass to a joint owner who survives or to a designated beneficiary. That's again where we look to a person's will, or in default of that, we look to what is known as the intestacy statute, which sets forth what happens to the assets of someone at death if they don't have a will and the asset doesn't pass to a joint owner or to a designated beneficiary. Wealth transfer in 2021 is actually pretty efficient at the time a person dies, because most people have most of their wealth either titled jointly with another, typically a spouse. As they get older, perhaps their children. And certainly most wealth that is in the form of financial wealth, bank accounts, retirement accounts, stock portfolios, most of that wealth allows for, and people exercise their right to designate beneficiaries of that wealth at the time of their death. The last issue with respect to wealth transfer that I wish to address is tax. A lot of discussion is had publicly about how wealth is or should wealth be taxed at the time of death. People have strong opinions on that issue. I want you to basically just note the facts. And the facts are these. In 2021, most states have abolished what are known as inheritance taxes. Most states do not tax, for purposes of state revenue, the transfer of assets upon death. Michigan, by way of example, abolished its inheritance tax effective October the 1st of 1993. For anyone who dies in the state of Michigan after October 1, 1993, there is not a state death tax. There is no inheritance tax. Of course, that is the date that Michigan increased its sales tax from 4% to 6%. It's the date upon which Michigan increased its transfer on real estate tax from $1.10 per $1,000 of transfer to $8.60 per $1,000 of transfer. So while the inheritance tax was eliminated back in 1993, the tax on the transfer of real and personal property on the living was increased. The estate tax is the tax that is levied by the federal government on wealth that transfers by virtue of a person's death. It does not apply to very many people, percentage-wise. And the reason for that is as follows. The first $11.7 million of wealth that is transferred is exempt from federal estate tax. So you can have up to $11.7 million of value that is exempt from federal estate tax at the time of death. That eliminates the federal estate tax for obviously the overwhelming vast majority of people. Number two, that which gets transferred to a surviving spouse passes to a surviving spouse free of estate tax, meaning it can be billions and billions and billions and billions of dollars that pass to a surviving spouse. There is no estate tax when wealth passes to a surviving spouse. It's when the second spouse, obviously, that dies, that there would be the possibility of an estate tax. But here's item number three. A married couple can actually pass along in excess of $23 million to whomever it is that they would wish to inherit from their estates, because a married couple can combine their exemptions and use the spousal exemption to collectively pass along under the law of 2021 in excess of $23 million. Again, that eliminates the issue for the overwhelming vast majority of us. Now, when a person dies and they have wealth that while alive generated income for them, and in particular, if they were required to take required minimum distributions, IRAs, 401ks, 403bs by way of example, SEPs, the undistributed monies that would have been subject to income tax to the decedent will still be taxed to the recipients of that wealth. So if you have a family member who was older, who was taking required minimum distributions on an IRA and they die, that which you receive that would have been taxable to them will still be taxable to you. What survivors are able to do is they're able to spread that income out over the course of their lifetime by rolling those retirement accounts into their own retirement accounts. But there still is the possibility of income tax on inheritance if that which is received would have been taxable to the decedent at the time of their death. The last concept that is of note is that under the law currently, when you inherit, you are entitled to what is known as the stepped up basis. In other words, the value of the asset that you're inheriting is valued at the time the person whom you're inheriting it from dies. And this goes a long way towards eliminating or at least minimizing capital gains on the later sale of in particular real property assets or stock. I'm not going to tax you on tax But I do want you to be aware of these concepts because you hear a lot of discussions about death tax and inheritance tax and estate tax consequences in the media. And I do want you to have the nuts and bolts really of how it all works. The last concept that I wish to cover with you as it relates to the law of property is the issue of intellectual property, because the law of personal property, as I indicated to you, is divided into the law of tangible personal property and intangible personal property. And I think for purposes of our sessions, an understanding of intellectual property is important. One of the things that can be difficult, I suppose, about property law, particularly in practice, is what law applies. Well, the law of real property is really quite easy. The law that applies to most of the issues of real property are the laws of the state or the city wherein the real property is actually located. If it's property that is located here in the state of Michigan, we are going to apply the laws of the state of Michigan to resolve whatever land dispute issues arise. With respect to tangible personal property, that's not quite as easy. And as we talked about with the Uniform Commercial Code, we'll apply a state law to resolve a dispute. And we've tried to make state law as uniform as possible so that if you're buying and selling something over the internet, that dispute isn't going to necessarily be resolved in a manner that is beholden upon a difference that exists between the law of the state of Illinois and this law of the state of Michigan, by way of example. Intellectual property is governed by federal law. Intellectual property is the law of the mind. It is the law of value associated with an invention, an idea, a concept, an image. You see that very famous logo on this lecture slide. And I, with great frequency on the lecture slide, show you different images that we associate with our university, our Sparty. And yet you see at the very bottom of that image, the R that is encircled, because we're letting everyone know, hey, that image, that registered trademark is associated with Michigan State University. If you're going to use that image, you're either going to have to pay for the right of the use of that image, or you're going to use that image with the permission of the owner of that image, and that is Michigan State University. Article 1, Section 8, Clause 8 of the United States Constitution, Congress shall have the power to promote the progress of science and useful arts by securing for a limited time to authors and inventors the exclusive right to their respective writings and discoveries. This is at the heart of intellectual property, the fact that we allow for our government, and in particular, we designate the federal government as having the authority to regulate the ability for people to profit exclusively for a limited period of time for the inventions or creations that they generate. The objective of intellectual property law is to create the framework that creates an incentive for people to develop and establish things that are of value. I am still smiling at our most recent victory on the football field against the University of Michigan, and as has become somewhat the custom, the athletic department comes up with a different way of using the Spartan brand, and you'll see on this lecture slide a picture of the helmet that was used in the most recent game against the University of Michigan. You'll also note that you can go up online and you can actually buy that helmet Not that I'm suggesting you do that, but it's a way, again, of marketing, of branding, of generating revenue. That color image, that helmet, that use of the Spartan logo has value to it, I think, in particular, since Michigan State won the game. The development of new ideas and inventions benefits society by allowing the public access to goods and services. Think of the pharmaceutical industry. And certainly, yes, while we get frustrated at how much we have to pay for pharmaceutical drugs, it is nevertheless amazing the uh, effect that these drugs have on creating, for those who have the benefit and the opportunity to utilize those pharmaceutical drugs, safer, better, healthier lives. And certainly in the midst of a pandemic, we recognize and see the impact of a robust, effective pharmaceutical industry and the speed with which they're able to develop vaccine. I was reading recently that the Google store now has something like 2.6 billion apps available for various various purchase and acquisition. And I look back on the concept, and I have to correct myself. I might have to look this one up. It might be 2.6 million. 2.6 billion does seem a bit amazing. I think it's 1.6 billion iPhones have been sold, and it's 2.6 million apps that are available for download. Again, not something that will be on your exam, and yet an astronomically large number. When if I may share with you that even in my lifetime, I practiced law, I think, for 6 or 7 years before I even had what we referred to then at that time as a mobile phone. And we recognize how industry has changed from the very time that Apple first put out the iPhone. The spawning and the development of business and opportunity and jobs promoted by intellectual property and the ability for individuals and businesses to profit exclusively, at least for a limited period of time, upon their invention. It's the give and take. You get to use what we have developed. We get to profit exclusively for a limited period of time based upon what we have developed. For our purposes in the course, what I'd like you to know is I'd like you to know the 4 principal types of intellectual property that exist: the patent, the trademark, the copyright, the trade secret. And in fact, for purposes of exam number 3, all I really am going to want from you is to understand the big picture, the purpose, the objective of intellectual property, and for you to be able to distinguish the patent, the trademark, the copyright, the trade secret, one from the other. This is made, I think, particularly easy in the form upon which the exams are now presented, in that you'll have those definitions directly in front of you, and you should be able to sail through those questions, I think, with relative ease. But I think it is important as a takeaway from the course for you to be able to understand what a patent is, what a trademark is, what a copyright is, what a trade secret is, how these are intellectual property interests that are protected at the federal level. The United States government, the patent and copyright offices of the United States government are in place to promote the protection of the creative works and ideas and inventions and concepts for the overall benefit that I have suggested to you exists. In sum, the patent is the ability for the inventor or creator of a device, or a better way of utilizing the device, or a subcomponent of a device, to profit exclusively for the use of sale of that device, and those who are going to include or use that device in other devices that they create or generate thereafter. The trademark or service mark is that intellectual property uh, right that we associate with a brand, with an image, the Spartan logo, the apple with the bite taken out of it, the fact that you'll be driving at night and in the distance you'll see the golden arches and recognize that up ahead is McDonald's. There is value associated with these uh, intangible images, words, concepts that we associate. This doesn't mean that every time there is the utilization of a name, an image, a brand, a likeness, that there is value that can be registered. We saw some years ago Ohio State University attempt to trademark the Ohio State University, and the courts said that attempt would be unsuccessful. We saw LeBron James try to generate and get a copyright on Taco Tuesday, and was unsuccessful in that attempt. But there are certain brands, images, phrases that we associate directly with a particular business or university or product, and these are subject to at least the attempt, the effort by those who wish to restrict the use of that image through trademark, service mark in registration efforts. The trade secret is probably the most difficult concept to grasp as it relates to intellectual property. The concept of the trade secret is that we do at least allow for businesses to attempt to protect a formula or a process or practice that is unique and developed unto that business. The idea of trade secret is more along the lines of trying to enforce that which an individual learns while working for another, from taking that and going out and using it unfairly in competition with the former employer who provided that information to the employee. We wouldn't allow someone to go and work for Kentucky Fried Chicken, by way of example, learn all of the methodology, all of the spices associated with the production of that finger-licking good chicken that they're proud of, to then go out and open up a rival utilizing all of the same techniques and spices used by the Colonel. The concept of the trade secret is perhaps the most difficult of the intellectual property right to protect, in that through reverse engineering, even through marketing, we really know what is the secret recipe within Coca-Cola. We know what certainly is contained within or upon the Big Mac. Your parents, if they are close to my age, probably fondly even remember watching Saturday morning cartoons where McDonald's openly bragged, if you will, upon what was contained within the Big Mac. 2 all-beef patty, special sauce, lettuce, cheese, pickles, onions on a sesame seed bun. I may get old and forget many things, but at a young age, at an impressionable age, over and over and over and over, I heard the advertisement that the Big Mac contained 2 all-beef patty, special sauce, lettuce, pickles, onions, cheese on a sesame seed bun. And that's something that I'll remember certainly probably for the rest of my life. Nevertheless, if I go out and try to market a burger and advertise that that is the contents of that burger, I'm going to be subject to a trade secret violation, even though the concept of the secret is perhaps a bit of a legal anomaly, a legal fiction. Finally, the copyright. Uh, we allow for the creator, the generator of content to benefit exclusively from that content for a limited period of time. This is not the intellectual property protection upon a word or a color, um, but it is the intellectual property protection that we will allow for when someone takes a series of words and puts them together. I would take by way of example that we are not permitted to um, protect exclusively the word on or the word the or the word banks or the word of. But if I put together the words on the banks of the Red Cedar, there's a school that's known to all. That song, the Spartan fight song, is something that is subject to copyright protection, although independently, the words themselves certainly are not subject to intellectual property protection. The sum of the parts is protected under intellectual property law. The parts themselves, not. So when we have an image, when we have a photograph, when we have a painting, when we have a poem, when we have a song, when we have a sound that we recognize is something that is created um, by putting together the sum of other parts for the generation of an outputted item, um, that output is subject to intellectual property protection. Now, I like to point out always and remind you always that the law is not subject to intellectual property protection. You will see from time to time lecturers, professors who will copyright their lecture slides or copyright their notes or copyright their PowerPoint presentations. Um, Not that anyone would want to reuse mine, although feel free. The fact is that I do not believe that there is any content that I deliver in the PowerPoint presentations, in the lecture notes, in the lectures themselves, that is subject to intellectual property protection, because the law is not something to which we are able to claim a copyright or some form of intellectual property control thereof. There's not a lot on exam number 3 as it relates to intellectual property. I do certainly want you to be aware of the purpose of intellectual property laws and the different, particularly the 4 main types of intellectual property. And if you're able to apply those to a particular set of facts and say, that's a copyright, or that's a patent, or that's